Welcome to Justice for New York. I'm your host, Charles Collins. All documentation concerning Justice for New York videos can be found at justicefornewyork.com. There are also family court petitions concerning the right to a jury trial, petitions to vacate support magistrate and judicial hearing officers' orders as they are issued in violation of the New York State Constitution, and there is also a demand for probation reports and psychological evaluations that the court orders, but the court orders that you can't read them or see them. That is a violation of your right to due process and equal protection of the law. They also order that the people preparing these reports do not have to testify and there is no accountability. This has to stop. Demand your reports so you can know what's being told to the court. And now for our presentation. Thank you. Okay, now we're going to talk about the Majauskas formula. Remember I stated in my opening that the state is defrauding state workers or anybody with a pension plan out of millions of dollars, and the Majauskas formula is what the Court of Appeals came out with, I think in about 1984. And it was designed, like everything else the state does, is to deprive people that earn a pension of their pension benefits. This is in cases where they're divorced and the other party is entitled to a share of the pension plan. They have a very easy formula. The formula is you take the monthly benefit, divide it by, on the top is the number of years you're married, divided by the number of years in the plan, times 50% is the other person's share. Very simple. But is it? This is what happens. I'm going to use a state worker, for example. He was in the pension plan for 42 years. He was married for 19 years. Or it's the date of the signing of a separation agreement or filing of divorce papers. That's what determines marital property. If he had stayed a grade 14, he would have had a pension after the 42 years of $3,700. So you take the $3,700, the 19 years divided by the 42 years, which is 0.45, times 50% or 0.5 because she gets half of the pension, which is $832. Now, let me explain something first, make it a little bit easier for you to understand this. Basically what happens, say you have a $1,000 a month pension. The first $500 is automatically belongs to the person with the pension. The second $500 is prorated based upon how long you were married and the number of years in the plan. So if you were in the plan 10 years, or in the plan 20 years but married for 10, that's half the time. The $500, she would get $250. The person with the plan gets the $500 plus $250 for $750. That's how it's done. So if he had stayed a grade 14, she would have received $832 out of his $3,700 pension. But because after he was divorced, he got promoted. He went from a grade 14 to a grade 27. So he got a boost of $5,600. Divided by 19 years, divided by 4.45, 50% to her, $1,260 she now gets. That's a denial of due process and equal protection of the law. She just got a $400 some odd $428 per month more because of his hard work. This was money earned after they were divorced, not during the marriage. Marital property ends when you get either signing a separation agreement or a divorce. It is unconstitutional as it deprives the plaintiff of due process and equal protection of law, and it violates Domestic Relations Law 236BC. That is requiring the husband to provide to the wife an extra $428 per month or $5,136 per year on his pension that was earned after the parties signed the separation agreement. After 20 years of retirement, this comes to $102,000 plus cost of living increase that he is also out of. Further, the husband is also losing another $4,000 per year for the cost of the option for the wife to continue to collect his pension after he dies. He didn't know it was going to cost him to give her that option. This cost should be solely the responsibility of the wife, as it only benefits her. But he's the one paying the majority of it. Domestic Relations Law 236B defines marital property. The term marital property shall mean all property acquired by either or both spouses during the marriage and before the execution of a separation agreement or the commencement of a matrimonial action, regardless of the form in which title is held, except as otherwise provided in the agreement pursuant to subdivision 3 of this part. Marital property shall not include separate property as hereinafter defined. The term separate property shall mean property acquired before the marriage or property acquired by bequest, devise, or descent, or a gift from the other party or spouse. Compensation for personal injuries. Property acquired in exchange for or an increase in value of separate property, except to the extent that such appreciation is due in part to the contributions of efforts of the other party. Basically what that means is your wife owns a house, you put a garage on, it costs $5,000, you paid for it, you're entitled to be reimbursed for your work and effort in putting the garage onto the house to increase the value. Nowhere, once you're divorced, there is no more marital property, period. There's no argument about that. You cannot claim marital property once you're divorced. The granting of an increase in benefits to the wife based upon the increase in plaintiff's pension plan due to his initiative and hard work after signing of the separation agreement is not marital property, and such the defendant is not entitled to this increase. Wait till you see. The Majewski formula does not take into account any bonus that the husband may receive from his longevity with the state or any bonus he may receive for retiring earlier. She gets part of that too. The bonuses are included in his pension, and the wife gets a share of these bonuses that were acquired after the divorce and are not marital property by state law. When the husband has the pension, in most instances, both attorneys, his and her, have him take the option for the wife to continue to receive his pension after death. Further, based upon this option, the husband receives less in his pension each month that he is not told, and they do not tell him he is paying for this option out of his pension. When the wife has the pension, they don't even mention to the father about getting it after she's dead, because that would cost the wife money. Further, they also have him give her the death benefit that completely eliminates a second wife from getting any portion of his death benefit, even if they were married longer. The wife should be able to receive that portion of the marriage and the rest to go to his children or second wife. He is under no obligation to support the ex-wife after he dies, except what his attorney and hers tell him to do. But they tell him that this, and then they say, well, it's in the Majewska's formula, so you have to agree to it. If the wife wants the benefit, she should pay for it by reimbursing the husband for loss of his income. In short, the father's attorney sells him out, in most cases. Now, this sounds pretty simple. Now we're back to the court system again. In 2013, somebody raised that issue again. And this is what our illustrious appellate court ruled. According to the defendant, the quadro entered by the court improperly awards plaintiff, in other words the wife, a portion of his separate property, his pension, what he made afterwards, i.e. the increases in his retirement allowance attributable to step increases and promotional increases in his pay that occurred after the date of commencement of the divorce action. We reject that contention. As the Court of Appeals stated in Majewski, we're back to this again, where the pension participant made a similar argument, the fact that a participant's 3 highest years of earnings may occur after the divorce does not affect the alternate payee's marital share of the pension benefits. Since each employment year is counted for pension purposes, each contributes to the high salary years. What a bunch of malarkey again. She shouldn't be able to get another $500 based on his work. You know, they're just wiping it out. In other words, you have a pension, and you can't switch pensions once you're in one unless you get different jobs. And people aren't going to give up their state jobs or whatever. But they're taking them out of this guy $5,000 a year extra that was based on monies earned afterward. His highest 3 years shouldn't be counted for her share of the pension because they were not married during those 3 years. In other words, they're deliberately screwing over a person with a pension. They're depriving them of their full pension. They're taking non-marital property, what he earned after the marriage, and giving it to her, and then giving her a higher rate on the pension that she's not entitled to. This is how corrupt the New York State judiciary is. And it's got to end, and people need to be able to keep their pensions. I'm not arguing that a spouse is entitled to a fair portion of the pension. But it should be based on what the pension is at the time of the divorce, and then you can add, if they get interest and stuff on it, I can understand ordering the interest and stuff be accumulated because they can't collect the pension. But only on their share of the pension, not on the other party's share. And not saying, well, I'm entitled to this higher pension because he worked harder. It's got to stop. This is what New York State does to state workers and others that have pensions, whether it's through GE or any other big company. They're screwing them over with this Majewski formula. And they keep doing it, and it's a denial of due process. It's a denial of equal protection of the law. And it's got to end now. The judges are deliberately violating domestic relations law, which states marital property is anything from the date of the marriage to either signing the separation agreement or filing for divorce papers. Obviously, anything after a divorce or signing a separation agreement is non-marital property. But this court ruling, Majewski and this other one, Loy versus Loy, clearly are saying, we're not following that. Anything you make afterwards is now the other party's share. You're still sharing. It's still equitable distribution. They don't have the right to do that. This is what they do. They're corrupt. They're ripping off people left and right. This is what the Democrats do. You know, they keep talking fair share, fair share. Well, people aren't getting their fair share because of the Democrats in this state. And if you're a state worker, this is what they're doing for you. So keep voting for the unions and the Democrats to sell you out. And one final thought. The reason why the judiciary does not want to declare the Majewski formula unconstitutional, as it deprives those receiving their pensions of due process and equal protection of the law when it comes to them receiving the full amount they are due by having the alternate payee, those who they divorce, receiving a greater share than they are entitled to, is that this has been in effect since 1984. There are tens of thousands of court orders and separation agreements that have been based upon the Majewski formula. It would be basically opening up Pandora's box by declaring that the Majewski formula does not comply with the law, as it deprives litigants of their constitutional rights to due process and equal protection of the law.